Welcome back to another episode on Legal Stories. Today, we are looking at the case of Natural Valley Limited versus Fairly Bottling Limited and 6 others. Appeal number 61 of 2016. The appellant, Natural Valley Limited, produces bottled water under the registered trademark Manzi Valley, registered in Class 32 at the Patents and Companies Registration Agency, PACRA. To distribute its water, Natural Valley invested a significant amount of money in manufacturing large 18.9-liter recyclable plastic bottles. These bottles were specifically molded with the words Manzi Valley noticeably embossed on the body and additional wording at the bottom stating property of Natural Valley Limited, Strong and Manzi Valley. Natural Valley supplied these filled bottles to customers on a returnable deposit basis, primarily for use on water dispensers. However, Natural Valley discovered that several competing water companies were using Natural Valley's empty 18.9-liter bottles. These competing companies were placing their own adhesive stickers over and on Natural Valley's bottles, filling them with their own water, and selling them across various retail outlets. Natural Valley issued a writ of summons in the High Court claiming, among other things, an order for delivery up or destruction of all infringing materials, an inquiry into damages for trademark infringement, damages for passing off, and an interim injunction to stop the respondents from using their Manzi Valley bottles. Passing off, a legal wrong committed when one business sells its goods in a way that misleads the public into believing those goods are the product of another business. Interim injunction, a temporary order issued by a court to restrain a party from continuing a specific action until the final outcome of the case. The respondent companies opposed the application. They argued that they had not copied or used Natural Valley's registered logo. Natural Valley did not hold a registered industrial design or patent specifically for the shape of the 18.9-liter bottle. And there was a long-standing practice in the Zambian bottled water industry, lasting over 10 years, where empty bottles circulated freely among companies. They claimed customers exchanged empty bottles at retail sites regardless of the brand name embossed on the bottle, and dealers simply collected and refilled whatever empty bottles were returned. They argued that placing their own adhesive stickers on the bottles prevented any public confusion. The High Court judge initially granted an ex parte, one-sided temporary injunction, but after hearing both sides, he discharged or cancelled the injunction. The High Court judge found that Natural Valley had raised serious questions and a good arguable claim, but Natural Valley failed to show that it would suffer irreparable harm. Any financial loss could be adequately compensated by an award of damages, monetary compensation at the end of the trial, and stopping the long-standing industry practice of bottle exchanges during the trial would cause greater inconvenience to the market. Natural Valley appealed this discharge to the Supreme Court of Zambia on 3 grounds. The Supreme Court carefully evaluated the 3 grounds of appeal and applied established legal principles. Ground 1. Adequacy of damages and irreparable injury. Natural Valley argued that damages were not an adequate remedy because tracing and quantifying the loss across the country would be speculative and impossible. The Supreme Court agreed with Natural Valley. The Supreme Court took judicial notice that Natural Valley's bottles were distributed nationwide. The court ruled that it was practically impossible to physically find, track, and account for every bottle in circulation across the country to calculate financial loss. Therefore, any attempt to measure damages would be subject to speculation and lack of certainty. The Supreme Court rejected the High Court's finding and held that Natural Valley would indeed suffer irreparable injury if the injunction was not granted. Grounds 2. Balance of convenience. The High Court judge had ruled that the balance of convenience favored maintaining the existing state of affairs of bottle exchanges in the market. The Supreme Court held that there was no need for the trial judge to consider the balance of convenience at all, because the evidence clearly showed that Natural Valley faced irreparable injury. Balance of convenience only comes into play when there is doubt about whether money damages are adequate. Under Ground 3, Natural Valley argued that because it proved a strong claim on initial appearance and alleged statutory breaches by the respondents, the injunction should automatically remain. The Supreme Court clarified a key legal point. While establishing a prima facie case or raising serious questions is important, it is not on its own sufficient to grant an injunction unless the applicant also proves irreparable injury. Therefore, while Ground 3 failed as a standalone technical argument, the Supreme Court ruled that its failure was minor because Natural Valley had already succeeded on Grounds 1 and 2. The Supreme Court allowed the appeal, set aside the ruling of the High Court, and granted the following interim orders pending the final trial. Interim injunction granted, restraining all 7 respondent companies from marketing or distributing water in Natural Valley's 18.9-liter bottles, bearing the registered trademark Manzi Valley. Order not to part with stock, restraining the respondents from parting with any bottled water in their possession or control contained in Natural Valley's 18.9-liter bottles. Surrender of bottles, ordering that all 18.9-liter bottles belonging to Natural Valley in the possession of the respondents be surrendered to Natural Valley, awarding legal costs of the appeal to Natural Valley. Here are 4 lessons we can learn from this Supreme Court decision. Unwritten industry practices do not neutralize registered trademarks. Claiming that everyone in the industry exchanges bottles does not create a legal right to use another company's trademarked property without their consent. When money is not an adequate remedy, if an alleged trademark infringement involves thousands of items circulating nationwide, making it practically impossible to track and calculate exact losses, courts will classify the harm as irreparable injury that cannot be fixed by money damages alone. When is balance of convenience considered? Courts only weigh the balance of convenience if there is genuine doubt about whether money damages are adequate. If irreparable harm is proven, the injunction should generally be granted. A good case alone is not enough for an injunction. Establishing a strong prima facie case is a required starting point, but you must also prove that you will suffer irreparable injury before a court will issue an interim injunction. Thank you for watching. Please remember to like, share, and to subscribe to our YouTube channel.